All right, I think we'll get started. My name's Seth Bloom. I'm Senior Director of Attorney Services at Levelset here in New Orleans. I'm excited to present another great webinar today from one of our attorney network lawyers, that's Joe Katz. Today's webinar will be on how subcontractors can avoid risk and the potential for costly lawsuits. Joe Katz is with Katz Law, and that's in the greater DC area. He's a construction lawyer. So without further ado, I will turn it over to Joe. If you have any questions, just post your questions during the presentation. We'll also save a few minutes for the end. And of course, you can always post them on the Attorneys Network Q&A section. So thank you so much for doing this today, Joe. We look forward to it.
Thank you, Seth, and everybody else at Levelset, Catherine and Garrett, and all the other people behind the scenes. Levelset really has been an important resource for contractors and subcontractors during this really new era for everybody, owners, GCs, subcontractors alike. Nobody's really faced construction during an ongoing pandemic before, at least not in our lifetime. Thank you also to my assistant, Dylan Shane, for, again, terrific work in really setting up the technology and the graphics for this webinar. So let me just first begin with what I'm not going to be covering today, which is really kind of beyond the scope of this webinar. One thing I don't really practice is employment law. So certainly the CARES Act on a national level, and many states have enacted state-specific legislation which governs employment law for the COVID-19 era, which includes firing. Can you fire an employee for just because you don't have to work during the pandemic? Can you fire them for not working, for not wanting to come in or go to work? Can you terminate somebody because they're dealing with somebody that's either been quarantined in the house or even schooling requirements? Almost across the country, public schools have resorted to virtual schooling, which means that anybody with school-age children needs to either be home themselves or take care of childcare, or even if, for the most part, it's taken care of, there's definitely emergency situations where coverage is needed. So an employee that's excessively missing, et cetera. And then conversely, employee rights, that's all that whole topic is beyond really my scope and the scope of this webinar. The other aspect that I'm really specifically not covering is, again, the CARES Act as it relates to financial type of financial and tax-related incentives, or different, the PPP loan, or now it's really everybody's focusing on PPP forgiveness, EIDL loans, other kinds of national, federal or state incentives on account of, or aid or assistance on account of the pandemic. Again, that's something that is not really in my wheelhouse and not something that I'm covering in this webinar. What I do is construction litigation. So typically, while many of my clients will consult me slightly when in an ongoing situation, for the most part, much of my the bread and butter of what I do is litigation. So dealing with problems that have accrued 2-3 years ago, 1 to 2 if it's a mechanics lien, it's less than that, but a payment bond will often be about a year prior. Other litigation will be 2 to 3 years prior, and that's the situation we're litigating. So from my viewpoint, COVID-19, the era of COVID-19 in terms of the changes and the claims that will come out of COVID-19, for the most part, is still, unfortunately, is still an unknown. We're just recently getting rulings from trial level courts on a lot of insurance related claims. From what I'm getting across the wire here on various CLEs or other legal news wires, unfortunately, for the most part, is the denial of claims for COVID-19 from an insurance perspective, often because the insurance companies have riders or really exclusions that exclude health or epidemic pandemic related occurrences. Now, again, remember that the situations that get to court is when, in this case of insurance companies, the coverage was challenged by the insurance company, citing some sort of exclusion for a pandemic or a health-related situation. If many companies might have had riders that covered that, and therefore there was no litigation, they were covered, and that issue didn't reach the courts. So court rulings, and it's also appeals have not yet really had any time to develop. An appeal normally takes about a year to make its way through the appeals court to a ruling on the appeal. So in terms of the legal world, we are still catching up. We always will be catching up to problems about a year or two out. But that being said, all that being said, there is still a lot that can be done, a lot that needs to be known, a lot that can be done both for current contracts and future contracts. And that's really the topic of today's webinar. We named it Change Orders to really be able to drive home that this is your mid-contract, COVID-19 has hit and now impacted your project. That's the perfect groundwork for a change order, and that's what we're covering today. Okay, so everybody knows, mid-March, certainly by April, construction, like almost every industry across the country, took ground almost to a complete halt. Many states had some sort of exception for construction as being an essential service that can continue, but even so, the office oftentimes had to be, people were working from home, and there was really a disruption in April. Even if your state said, construction remains essential and ongoing, I know I experienced from my clients, March and April, real slowdowns as kind of everything was sinking in as to how this is going to be developing in the coming weeks and months. Now, if we look here at my second bullet point here, by September, jobs are coming back, but there's still, about a third of the jobs that were lost remain unfilled, causing a labor shortage, as everybody is probably aware, and sharp increase in prices. I have here that lumber prices increased 30% in September. I think from what I'm hearing from clients, overall, lumber has nearly doubled in price, from this time last year, for pre-pandemic last year. Now, a lot of that apparently is related to a bump in residential construction because of the historically low interest rates we're seeing. But regardless, work that maybe was under contract but not yet performed, to the extent it involved lumber, steel, concrete, those prices have shot up significantly and certainly can affect trade contractors' bottom line. Now, this is an area that would be ripe for a change. Moving forward, contracts that are being signed this week, next month, if COVID-19 has taught us anything, I think it's that things can change on a dime. Prices, if there's a second wave, there could be shutdowns again, increased labor shortages, even increased, greater increases in prices. And the way to kind of plan for the future is really now inside of our contracts and our subcontracts. All right, and that's kind of what I was just talking about. So both repurposing, standard contracts for the most part are standardized. We've got the IAEA, the American Institute of Architects suite of documents. We've got consensus docs. Of course, the federal government, not only are the contract clauses standardized and actually in the FAR, interpretation is for the most part standardized across the spectrum of litigation. Has built a body of law that interprets the government contract clauses pretty uniformly. But beyond that, beyond what we're calling actual standardized contracts, even a contractor or an owner that doesn't use one of the actually standardized contracts, for the most part, internally they've got a standard contract that all the trade contractors have to sign. We'll talk as we get a little bit deeper. We'll talk about modifications that could and should be made by trade contractors to these GC standard contracts. But remember, everybody's working within a space of standard contract terms. They'll differ slightly, but for the most part, everybody knows change orders, differing site conditions, delays, suspensions. All these things have been in construction contracts for decades. Now, not necessarily anticipating a worldwide pandemic and those effects. Now that we're living it, we can repurpose the contract clauses that we're already dealing with and look at them with COVID glasses to see how they can help us, how they can recoup some of our losses. Throughout, let's remember that whereas the president announced a national emergency, whereas governors across the country have signed executive orders for whether it's their stay-at-home orders or other orders that limit what can occur, timely performance of your contract is for the most part still an obligation of a contractor and a trade contractor, pending whatever else is going on. So if we're talking about claims for payment, right? Your GC should still pay you if that time frame has arrived, regardless of whether the contract is stalled, he's been paid by the owner, et cetera, et cetera. So a claim for payments should still be made, and performance, unless it's been halted, still on some level needs to either occur, and if it can occur, that'll take us into what I think is our next slide. Well, it's not, but it's a little bit later on. We're going to talk about what do you do if you've been, it is our next slide. If you've been delayed, how do you account for that delay? And how do you raise your hand and say, COVID-19 is impacting my ability to complete my work under my schedule. Force majeure clauses. A force majeure clause basically says some outside force, some outside situation, not my fault, of the contractor or the trade contractor, is preventing my performance of this contract, of this work. And many contracts will have a force majeure clause, many will not. Even if a contract does have a force majeure clause, what we do see coming through the courts now is if it addresses a pandemic, if it addresses a national emergency, for the most part, COVID-19 will fall into those categories. If it gives samples of what it addresses, such as acts of terrorism, acts of war, natural disasters, or acts of God, and it does not include specifically a pandemic or a national emergency, So then there'll be some question. Well, is COVID-19 an act of God or not? Many will have, and that goes to my first bullet point here, catch-all language. Anything outside of either party's control. The IAEA, I believe, does have that language. So for the most part, COVID-19 can be covered when there is a catch-all. When the force majeure language is too narrow, courts are saying that they've spelled out 4 situations: terrorism, natural, weather-related disasters, war, and something else, and not a pandemic or another health situation. And courts will exclude this situation from a force majeure right to time extension. Often a force majeure clause will also allow for termination. But again, everything needs to be looked at in terms of whether the COVID-19 situation can be included. This is what we were just talked about. Does the clause only give you a time extension, or does it also give you increased costs? Time extension is good on its own, which means that you can no longer be held liable for the failure to reach your schedule on time. Those amounts could be catastrophic. If you think about university or college housing, and if the goal was to have construction complete so that this housing can be leased up to students in July and August in advance of the start of the school year, the college year in September, and now those timelines have gone by, construction's delayed, it can't be shown, and it's not even done. So it certainly can't be leased up and filled before the start of the school year. That owner, that developer, can make a claim for millions in losses from an entire year's worth of lost use, is what it's called.
Joe, I just wanted to jump in for a second. And again, we have a pretty big room full of people. So I just want to encourage people to ask any questions if you have them, and whether get to them during the presentation or right after. Everyone's being a little quiet today. So thanks, Joe. Continue. Sorry for the interruption.
Thank you, Seth. And I welcome questions, both because it kind of breaks up the monotony, and it's a challenge that I'm happy to take on. Okay, so an AIA contract, that clause is there. I've got that up on the next slide. Government contracts, I'm going to have that up as well. Consensus docs, I couldn't find a consensus docs provision to put up there for you, and I'm not sure how widely used consensus docs are versus the AIA. There's the AIA clause, and it's got, it doesn't, if I remember correctly, it does not call out. It's got labor disputes. These are what would entitle a contractor to an extension of time. We've got labor disputes, fire, delivery delays, casualties, adverse weather. So far, COVID isn't any of those. But we've got here a catch-all phrase, or other causes beyond the contractor's control. So certainly national shutdowns or statewide shutdowns of work, or simply not necessarily, even if construction in your state is essential and is going on, if your access to labor because of the pandemic is stymied, then that should certainly be covered by the IAEA clause. This is only a time extension. I do believe that, I don't have it here, but I believe 8.3.3, three sections down, the AIA does indicate that this doesn't affect delay claims for cost, meaning that if the contract otherwise allows for it, then excess costs can also be sought. This is the FAR clause. This is for federal government work of the prime contractor and for the subcontractors. And you'll notice over there, item number A5 includes epidemic, and item number 6 includes quarantine restrictions. And this is kind of a golden, anybody working on a federal job that's been impacted. What this, just as a frame of reference, this FAR clause talks about excusable delays, meaning this is not something that a contractor or a subcontractor can be held liable for if they can't meet the construction schedule. That would be epidemics or quarantine restrictions. It itself does not entitle a contractor or a subcontractor to additional funds because of increased costs arising from an epidemic or quarantine restrictions, but because it's by law, by federal law, considered an excusable delay. So at the time that work is restricted on account of COVID-19, whether by a stay-at-home order or any other restriction, there's, I know, clients of mine have sought extra costs as either a change or a constructive change. The requirements of construction and performance have changed because of distancing requirements, because of access to the work. So,
Joe, we do have a question coming in, not to cut you off.
Sure.
It's from one of our attendees. Typically, we see contracts that limit bind subcontractors relief to the relief that GCs receive from the owner. In that dynamic, if the GC absorbs the COVID-19 cost, subs are expected to absorb the cost too. How do you force the GC to pay you for these pandemic cost impacts, regardless of whether they get paid by the owner?
Okay, so that's a great question, and I would point out that it's absolutely true that many contracts, will have what's called a Flowdown clause that says, whatever relief we achieve from the owner, pro rata extends to you as well. Remember, though, that for the most part, whether in that specific clause this questioner is referring to or elsewhere within the contract, it's generally going to be flow down and flow up. Pass through in the sense of claims from a sub can be passed up the stream through the GC to the owner. So if you're getting the short end of the stick, meaning the GC is passing on an owner refusal to recognize or a GC decision to absorb excess COVID costs, and is not passing up your change order, your PCO or change order request for additional funds on account of COVID-19, then that's a breach. That's typically a breach of the GC's obligation. So if you one way to think of it is a Flowdown. I have noticed that GCs have often taken the word rights out, but for the most part, certainly 10, 15 years ago, the clause always said that the subcontractor has all the rights and responsibilities that the general contractor has to the owner. So responsibilities we're all familiar with. You've got to comply in your subcontract to whatever the prime has agreed to do for the owner. Rights is a word that has a lot of import. That means that every right that the GC has in terms of going after the owner for additional time, additional costs, is also a right the sub has against the GC. So to answer the question directly, if your GC has decided to absorb COVID-19 costs from the owner, that's not something, without your agreement to do that, and you've sent up a notice or a PCO for those costs, that should not be, that's a decision that the GC now owns and has to address it with you, the trade contractor, and if there are increased costs, should be liable for them.
Joe, there was another one, and I think you answered a lot of the questions with this one, but I want the person to have an opportunity to ask it. Would a trade contractor, for example, a framing contractor, be able to charge the client or the homeowner for the increase in lumber that's happened recently? if the increase led to the contract amount to go over specifically when it came to the amount of what was charged in materials, for example, lumber.
Right. So that's a great question. That's exactly what we're talking about. And the answer to that, typically, tell me again, Seth, that was a trade contractor or a prime?
It was a trade contractor. So they used the
they're-
example of a framing contractor. So it was an anonymous person. So I'm going to assume it's a framing contractor.
Okay, so it's a framing contractor who's apparently under contract with a GC to build a house or a whole development of houses. And that's exactly this question has hit the nail on the head in terms of this entire presentation is to find in your contract where you can make someone else pay that bill, so you don't have to pay that 100% increase, that doubling in price of lumber because of COVID-19. Your contract likely doesn't say, oh, and by the way, if there's a national pandemic that raises the cost of lumber by 100%, then I can get a change order for it. Likely doesn't say that, right? Straight up like that. So it's would be my job as your lawyer to find within your contract where we can recoup that extra cost. And that's exactly what we're talking about. Things like changes, right? Change order clauses for unforeseeable situations. The concept here would be to say that okay, we're going to get into change orders. Right now, we're just talking about delay and how you certainly won't be held to a delay for that unforeseeable situation of getting the lumber if there's a lumber shortage, which I believe there is. Can you recoup the cost? That's what we're heading into next. Let's understand that some owners will start to suspend work, which will also lead to cost, loss of profits, loss of revenue by contractors and trade contractors. I was contacted by a church in May, June, that the membership had made a decision that we're going to suspend the construction, mid-construction, because we don't want to go and continue drawing down from our construction loan another $5 million to finish this construction during a pandemic when, for the most part, it's financed by the members, and their jobs were uncertain, their retirement accounts were uncertain, and they paid under, it was a standard IAEA contract, and they had to pay we negotiated with them pretty well, the other side pretty well, but ultimately they accepted almost a $200,000 penalty, being the lost profits of a portion of the work that was canceled, because they were suspending it for their own convenience. The contractor didn't do anything wrong, because they became conscientious about moving forward with construction during this situation. But again, a $200,000 penalty in their minds was much, much better than drawing down on a $5 million loan and not knowing if and when it would be able to be repaid. Contracts have suspension clauses, the IAEA suspension clause, what we just discussed, and then the FAR also allows for compensation if the government has suspended the work actually or constructively by restricting access or making it so inefficient to do this work under their guidelines that it just needs to be suspended. Then that can also be a basis for the increased costs, recovery of the increased costs. Remember that there are custom clauses, and again, trade contractors should, for future moving forward, should make sure that their contracts do include the ability to collect more for increased prices, for increase, whether it's materials or labor or the access of labor, the ability to put a pause on construction during shutdowns, or even if it's not many states, again, have allowed construction to continue, but it's sometimes just so impractical that it's better or cheaper not to. Okay, deadlines are continuing to run. Many courts until about June or July put the pause button on statute of limitations for filing mechanics liens or bond claims. But as far as I know, all courts are now open again, and those timeframes have run. I know here in Maryland, where I practice primarily, by the end of August, those timeframes had run, meaning that something that had become due in March, April, May, or June now was due by the first week in August. But after that, no continuing time extensions were being granted for the filing of lawsuits. And of course, notice requirements are still running in contracts. Mechanics liens bond claims are very sensitive to timeframes. By statute, Miller Act, you've got 1 year to file a claim in court. You only have if you're a sub, you only have 90 days to provide notice, 90 days from your last day of work to provide notice. Mechanics liens, states are all different, but many of them also have notice requirements for subs and filing deadlines as short as 90 days through about, here in Maryland, it's 180 days. REAs, change orders, many contracts will have time frames, 7 days, 10 days. Now, for the most part, there isn't prejudice, meaning that if nobody's lost money because you noticed them 11 days after you realize and not 10, that for the most part, courts will not necessarily enforce those too stringently. But again, better sooner than later. Okay, so to address now the specific question of lumber's increase by 100%, how do I recoup that? Change orders will typically talk about material price increases, delays from labor shortages, productivity losses, and consequential delays. So we're talking now about not waiving that requirement, documenting, right? So this is the contractor that wants to get paid for his lumber that's increased, needs to figure out where in his contract can he do that. Now let's put it right. So now's the time to really get creative inside your own company. Make sure that the front office and the back office and the field are all kind of talking amongst each other, so everybody knows the impacts the others are having, and then as well to reach out to a lawyer, your accountant, sometimes your surety representative. Right off the bat, I would say that it's likely that the construction itself was somehow impacted. The pace of the construction was somehow impacted by COVID, and the framing contractor can say, when construction shut down in March or April, I didn't know, it was unclear when it was going to resume. I couldn't place an order, not knowing when construction would resume. And now that we've resumed 2, 3, 4 months later, and I'm placing my order, prices are 50% higher. And you, general contractor, when the work shut down, even temporarily, you delayed my placing of an order, and that created a material price increase. So yes, the change of access to the work area, access to the job site, had a more far-reaching impact than simply getting work done on the day that we weren't allowed to be there. It was in terms of placing orders and the resulting increase in price that's come because of it. That would be one idea to someone that's asking, how do I get the price back for increased labor, for increased materials? And it would be the same for labor, right? If there's a labor was supposed to, the schedule called for framing work to keep going in April and May. Well, in April there was even a momentary shutdown. I couldn't get my crews together, and by the time June and July came around, where it was time to begin again, labor wasn't available. So when labor was available, I wasn't able to proceed with that, and that's led to increased costs or an inability really to get the right labor. Another way to try to attempt to get those fees back in terms of a PCO or a change order request. If the decision is made to kind of go for a across the board COVID-19 impact to the construction change order, or what we'll talk about in a minute, claim, then you'll want to consider a cost code related to COVID-19. And this would be anything from increased healthcare needs, testing, distancing type of plexiglass, or even the need to purchase individual tools if there can't be a generalized sharing of tools for whatever reason, and additional tools are needed, additional rental equipment if two people can't ride to a job anymore, and you've got to kind of or really scissor lift. Everybody needs their own lift. It could be any number of changes could lead to the increase of costs. And if you don't have a cost code flagging this as COVID-19 cost, it's just going to get absorbed in your generic job cost, and it's going to be very hard to separate what was call it a base contract cost versus a COVID-19 specific cost. I'm sorry. All right, let's make sure also that we're aware that we're not waiving change orders. Change orders can be waived. I often talk about changes, subcontracts, and changes, and in general, contract documentation as being like an IED. Kind of, it's been planted there already, inside the subcontract, inside the form change orders, the form partial releases. Inside there have been implanted these IEDs that are just kind of waiting to blow up in the trade contractor's face at the right time. So for example, subcontract language. A subcontract language will very often tie a trade contractor's hands in terms of what can be accessed, what can be recovered cost-wise. For example, a very common contract clause says, if there's delay, then excess time can be provided, but under no circumstances, it's called a no damages for delay clause. There won't be any excess money paid for delay. Time, yes. Money, no. And what contract is delayed where there's no cost increase? None. There's always time is money, and there's always a cost increase to delay on a construction job. But if you've signed a no damages for delay clause across the board, then you've already, without even stepping foot on the job site, you've severely limited your rights and your entitlement to change orders for increased costs of delay. But you're not, once you make sure that the subcontract doesn't have the no damages for delay clause, you're not home free. There are throughout the job, throughout the contract administration, there will be documents that will try again to get you to waive increased prices, increased costs for any type of changes. Change orders. The federal government is notorious for this, as are many GCs. When you execute one change order, you submitted, you noticed the drawing is unclear and or unworkable, and a change is made, an RFI is put in, and a change is made, and the cost goes up, $5,000-$10,000. Wonderful, you're going to get paid for that. Well, before you sign on that dotted line, read that document carefully, because many times it will say that By signing this change order, you're acknowledging that there are no other costs to the date of when you sign it, that there are no other increased costs through that date. And if you sign that during COVID-19, what you've just said is this design change is going to cost $5,000, $10,000 that I'm going to get paid for, and there are no other situations where I have increased costs. So you've just signed away your rights to recover for labor shortages, increased costs because of COVID-19. Not even thinking about that, thinking you're going to get to that later. Unfortunately, very, very often, there are change orders in the works, pending change orders already in the works. Your back office has already identified situations where there's increased costs, and those are in the works, and somebody just really oftentimes not reading it, not knowing, not realizing the impact, will sign one change order that effectively at that moment waives all the change orders currently in the works, because it says in there that as of today there are no other increased costs that we're seeking. We waive, it's a waiver of increased costs to that date. And then something that I really preach about whenever I have an opportunity is partial releases. And that's my last bullet point here on this slide. Partial releases are misnomers, and because they're not really partial releases, they're oftentimes full releases through that date and time, because the partial release will say, partial really just refers to the job's not over. That's all that word partial is reduced to, because the release says, will say very clearly, in exchange for X amount of money, we are waiving all claims for payment. Sometimes it excludes retention, sometimes it doesn't. So the trade subcontractor, or even the GC, is saying that in exchange for this payment on this day, we waive all money due for all work up to this point. Boom, you've just signed away any claim to a change order for any change that happened prior to that date. You just waived away potentially your retention, potentially, if you're signing this a month later from when the pay application went out, you just waived away your current month's billing that you haven't even billed yet. Now, as a practical matter, the GCs don't really use that release as a weapon against you, because if they did, they would very quickly not have any trade contractors willing to work for them. And this is something, frankly, that the folks at within the GC's accounting or AP department aren't even necessarily aware of. I'll tell you who is very, very aware of these waivers that appear in monthly partial releases, that appear in change orders, and of course that appear in subcontracts, are lawyers. So the lawyers, often experienced construction lawyers retained by GCs, in-house lawyers, and the lawyers for owners certainly, are just when a situation comes to their desk, and this is like a situation that crosses my desk, it's often about something that went wrong a year, 2, or up to 3 years ago. Somebody has a big claim now for money. It's gone through the eyes of several other people, the project manager, executive, president, etc. It's unresolved, and now we've got 1, 2, 3, 4, 500,000 or more, million, $2 million in unpaid PCOs, claims, etc. So now it hits the lawyer's desk. One of the very first things I ask for are, can I see the monthly releases that were signed throughout the job? And when I see those, and I see that money has been released month by month for any changes up until the day of signing that release, I know, if I'm representing the sub, I know that things are likely all over at this point, or risk being all over if not treated carefully, because release is a release is a release. If it smells like a release, looks like a release, walks like a release, it's a release. And a release is amongst the strongest terminology that courts apply and are bound to apply as plainly as written. So an argument that, well, this release, didn't include change orders, the fact that these change orders were, you had all these change orders, you had notice of these change orders for 6 months because we gave it to you. That's not usually going to be effective against a release language and a partial release that waives claims. That's really I would say one of the biggest dangers facing trade subcontractor or a subcontractor, and it's very easily fixed. The way it's fixed is by handwriting in there, or having your lawyer modify it, or handwriting in, except for, and list the changes that the PCOs that are outstanding that are accepting, or even just accept out generic language, something like except for claims that have been previously provided, notice has previously been provided upon, or unbilled work, extra work, something like that. For my clients, I provide a stamp that has this language already on there, and I tell them stamp it. Now, for the most part, it's done electronically, but for years, I've had clients stamping on every partial release exclusionary language so that lease doesn't function as a sword against them. Okay, so change order mistakes. Biggest mistake of a change order, doing the work without a change order. Virtually every subcontract and certainly every general contract is going to say you have to have a signed change order to do the work. And if the work is done without a signed change order, it won't be paid for. But yet, the minute after that contract is signed, everybody seems to forget what they just both agreed to in writing. And change order work, it's not a change order because it's not executed. Extra work or additional work or changed work is routinely done without a signed change order. And for the life of me, I can't understand why. My clients tell me, well, we want to be, particularly if they're a sub, we want to be a team player. We don't want to cause problems. We want to work in the future with this GC or this owner. And that's terrific. And all that can happen while you insist on a signed change order. You can simply, to me, the easiest thing, what I tell my clients to do is just send them the subcontract that applies, circle where it says change order work that's not signed. You cannot do change order work unless there's a signed change order, and say, I'm just following our subcontract. I can't, my hands are tied. I can't do this work until we have a signed change order. Or I tell my clients, make me the bad guy. You be the team player and say, tell them that your lawyer just won't allow the work to go forward without a signed change order. At minimum, there should be an email exchange saying to go forward with the work. Courts have held throughout the country that an email signature, just name at the bottom of the email or a pre-automated Outlook signature, is a signature as far as the plain meaning of signature, and it doesn't have to be a blue ink wet signature. It could be an email that has a signature at the bottom of it. So again, don't, to my second bullet point there, don't throw out your subcontract just because things are going differently. That contract, even though the scope of work might not be in there for the changed work or the extra work, that contract is still very relevant to doing the work and what needs to happen before you do that work. Unaddressed change orders, when that work is done and becomes a cost that hasn't been paid for, now becomes a claim, right? So the difference between a change order is that change order request, or a PCO, is when you're looking for a signature saying you'll get extra money and extra time to do this future work, to do this prospective work that you're going to do. When that's not signed, and you're told do the work anyways, do the work, and you're still not paid for it, then it becomes a claim looking backwards for excess costs of work already performed. Like we said in the beginning, the jury is still out on claims related to COVID-19. It'll take a year to two to really develop a body of case law addressing what aspects of COVID-19 are appropriate fodder for increased costs. It's definitely appropriate to talk to a construction lawyer now if you're experiencing increased costs. The advice I can give you now, not knowing what the future will hold in terms of COVID-19 claims, is that the three most common aspects of a claim for back-looking work would be the extended manpower and equipment costs. If there was delay and we needed more manpower to get it done, more equipment to get it done, home office overhead during the period of delay, and with or without a delay, the loss of productivity, the loss of efficiency, the same work costs more to get done because of whether it's labor shortages or distancing requirements, right? You can't have a crew of 20 anymore. You have to have a crew of 10. That's going to affect your efficiency. So something that can be done right now is to begin to monitor through a cost code or other ways, begin to monitor job specific, not just company wide, because if you're performing 3, 4, 5, 10 jobs, you're going to want to, and you've purchased more equipment or more tools or purchased PPE, whatever it is, you're going to want to allocate by job expenses related to specific expenses related to dealing with the COVID-19 situation. Again, a construction attorney, specifically a construction attorney, is really crucial to contractors and subcontractors these days. Seth, do we have time for live Q&A?
Yeah, we went a little bit longer, but that's okay. It was a lot of good information. We got quite a few questions, so I'll just pick and choose one or two of them, and then we'll wind down for the hour. But Diego asks, what if the GC submits the subcontractor cost and the owner rejects the costs? Would the GC still be liable to pay?
So even when an owner rejects the costs, usually the subcontract allows the sub as a pass-through with his own counsel to challenge that denial. Right. So in a perfect world, the GC should get back to the sub and say, hey, the owner has rejected your claim for costs. Are you willing to accept that, or do you want to challenge that by hiring your own lawyer? Or you probably have a lawyer if you submitted a cost upstream, by having your lawyer really take our place in a sense for purposes of continuing your upward claim. If they don't do that and they settle with the owner, then they've just bought the liability to that claim. So they're not going to pay you short of a judge or an arbitrator saying they have to. But you have that right to challenge them and say, you can't simply say the owner rejected it, so I'm rejecting it. You didn't give me the ability to chase that cost with the owner. So now we're going to litigate my entitlement to this cost. And if a judge or arbitrator says, yes, I'm entitled to it, then you bought that responsibility 100%, even though you never got it from the owner.
Okay, Joe, I think there's a few more questions, but I'm going to wind it up, and thank you so much for this presentation and webinar today. We really appreciate our attorney network lawyers that share their knowledge for all of you. Again, my name is Seth Bloom. I'm Senior Director of Attorney Services at Levelset. You can go to our attorney network question and answer. I posted it earlier, and ask any question that you have of Joe or anyone, and get a few different lawyers to answer it. At the same time, feel free to contact Joe directly if you're in his area and you have legal questions or legal needs. So Joe, thank you so much. And thank you to everyone who made this webinar possible.
Thank you. Thank you, Seth.
All right, everyone have a nice day. Thank you.